Good morning, everybody, and welcome to the WTO. I would first invite all of those of you who are not familiar to make sure that you're wearing your earpieces, because that way you can make sure to hear what is being said on the microphones. We in the panel are very glad to welcome the delegates from the countries of Rutenia and Burlandia to this panel hearing on the dispute Rutenia carbon charge. Firstly, I would like to introduce myself. My name is Jorge Castro, and I work in the WTO Secretariat. And I will let my fellow panelists introduce themselves. Maybe I'll start from my right, your left, with my colleague.
Good morning, everyone. My name is Irina Polovets. I work at the WTO Secretariat, and I'm also a fellow at the World Trade Institute. Good luck to both teams.
Good morning. Henry Gao, Professor of Law at the Singapore Management University. I also sit on the Academic Advisory Board for the Moot Court. So thank you all for participating in the Moot.
Good morning, everyone. My name is Jani Remy. I am the director of the Srinath Ramphal Center for Trade at the University of the West Indies in Barbados. I am also WTO chair for Barbados, and I also sit on the advisory board for the John Jackson Moot Court competition. Good luck, everyone.
Thank you. And now the colleagues on my left, your right.
Good morning, everyone. My name is Victor Crochet, and I work as a trade lawyer at the law firm Van Bellen Billis, and I'm also on the academic board of the competition.
Good morning. My name is Peter van den Bosch. I am a former appellate body member and currently director of studies at the World Trade Institute in Bern. I hope you don't find it as hot here as I do. They're saving on air conditioning.
Every year.
Every year. Okay.
Thank you, everybody. At this point, you should all be aware of the oath that you've taken in prior rounds, but just to make sure of it, can I ask you again, the students of the... beg your pardon. I'm forgetting a very important panel, which is who is not able to join us today in person, but is joining us remotely. Let's see whether she can introduce herself. Thanks.
Good morning, everyone. My name is Gracia Marin Duran. I'm a professor of international economic law at the UCL Faculty of Laws, and together with Irina, one of the case authors for this year's competition. So all the best to both teams.
Sorry for that, Professor. So again, as I was saying, you're all familiar with the oath that you've taken in prior rounds of the competition, but just to make sure, again, do you, the students of team number 1 and team number 97, arguing on behalf of Rutenia and Burlandia, solemnly promise that you will abide by the rules of the John H. Jackson Moot Court competition and the rules for the oral pleading, and that you will not communicate with or accept assistance from your coaches or other individuals in any way during this oral pleading?
We do.
Good. As you know, failure to comply with these rules or to accept help from outside sources, including coaches, can result in the bench recommending your disqualification to ELSA International. The panel now wishes to hear the appearances for the complainant in this matter. I invite team number 1.
Good morning, members of the panel, Mr. Chair. My name is Yulia Bulanok, and here today with me are my co-counsels, Ms. Alexandra Mikhailova and Ms. Yelizaveta Pogrebnyak, and we represent complainant, in this case, Burlandia. In the next 18 minutes, I will cover GET Article 3.2. Then, Ms. Alexandra Mikhailova will have 14 minutes to deliver on GET Article 11, and 21. Ms. Елизавeta Pogrebnyak will have 13 minutes to conclude our presentation by addressing GET Article 21 and 20. Mr. Maxim Mikityuk isn't present here today, but he contributed to our oral and written submissions significantly. We also reserve 5 minutes for rebuttal that I will be doing. Thank you.
Thank you. I now invite the respondent to present their appearances in this matter.
Good morning, distinguished panelists. Counsel for the complainant. My name is Mark Gitao, lead counsel for the respondent in this matter, the government of Rutinia. Alongside me are my co-counsels, Mr. Wayne Seymour and Mr. Alex Kiwara. Today, my colleagues and I will be responding to the three main claims raised by counsel for the complainant. I will begin by taking 12 minutes to address the first two substantive claims simultaneously by arguing that Articles 4 and 5 of Section 10 of the Net Zero Future Act are consistent with the MFN obligation under Article 1.1 of the GATT. Second, Mr. Wayne Seymour will take 12 minutes to address the third substantive claim. He will begin by arguing that Rutinia's carbon charge is not an internal charge, but an other duty or charge within the meaning of the second sentence of Article 2.1b of the GATT. However, should this panel find Rutinia's carbon charge to be an internal charge, Mr. Seymour will demonstrate that it is nevertheless consistent with both the first and second sentences of Article 3.2 of the GATT. Should this panel find violations of Articles 1.1 or 3.2 of the GATT, Mr. Alex Kiwara will take 21 minutes to demonstrate that first, all potential inconsistencies are justified under Article 21b3 security exceptions of the GATT, and this is because the measure at issue was taken by Rutinia to protect its essential security interests at a time of a climate emergency, which constitutes an other emergency in international relations within the meaning of that provision. However, should the panel find the security exception inapplicable, Mr. Kiwara will demonstrate that Rutinia's measure is nevertheless justified under Article 20b of the GATT, and it also satisfies the chapeau of Article 20. In conclusion, and with the panel's permission, we reserve 5 minutes for a rebuttal, which I shall be presenting. Thank you for your time.
I thank both team captains for this, and I would like to check with the timekeeper if these appearances presented match with the appearance sheets.
Everything is in order.
Thank you for that. We have heard the appearances that you have made, and we have noted that you intend to reserve time to address not just the claims, but also the defenses as have been described in the case. And we are interested in hearing arguments on both sides of the issue, of course. And just to warn both teams, the panel does intend to ask questions during your intervention, so be prepared also for that. At this point, then, I would like to invite both teams to start making their own submissions. So we'll start with the complainant, and timekeepers, please commence the timing. Thanks.
Once again, good morning, members of the panel, Mr. Chair. My name is Yulia Bulanok, and from now on, I will have 18 minutes to show you that Rutenia introduced trade restrictive and discriminatory measures, presenting them as robust climate change combat. And we will begin with thoroughly guiding you through GET Article 3.2. But before we move to the substance, let us show to the panel what is happening in the present case. Members of the panel, Rutenia introduced Net Zero Future Act at a perfect timing for itself, when its largest glass producer, that is Guta, has its emissions at a record low level and is fully ready to pay the carbon price. But in Burlandia, the situation is the opposite, and the complainant is heavily dependent on its glass industry, and therefore carbon charge jeopardizes our competitive opportunities and national treatment under GET Article 3.2. Considering this, we will proceed with presenting the consequences in the following order. And we will start with the first sentence of GET Article 3.2, and if panel isn't satisfied with our argumentation under the first second, we will proceed with the second. And our argumentation under the first sentence is threefold. First of all, we will show you that carbon charge is within the scope of GET Article 3.2. That is why carbon charge is an internal tax. Then we will demonstrate that Burlandian and Ruthenian flat glass is like. And finally, under the first sentence, we will explain why carbon charge leads to excessive taxation of Burlandian producers. And starting with our first argument, that is why carbon charge is within the scope of GET Article 3.2. The complainant believes that carbon charge is an internal tax. And here we follow the criteria developed by the previous panels. And the first one is that internal taxes are accrued due to internal event. And second, internal taxes apply both to domestic producers and importers. And now we will demonstrate why the said criteria are satisfied in Burlandian case. For this, we invite the panel to look at paragraph 18 of our case. It's page 6, namely Article 1 of the Net Zero Future Act, paragraph 2. And with respect to the first criteria, that is accrued due to internal event, we invite the panel to the following extract, namely, and I quote, "The charge applies to the following goods placed on the market in Ruthenia." From this extract, we understand that the obligation to pay the carbon charge is triggered by an internal event, namely by placing Burlandian flat glass on the market in Ruthenia. Hence, carbon charge is triggered by an internal event.
Counsel, if we were to disagree with you, and if we were to side with the respondent who argues that the measure falls under the scope of Article 2, not Article 3, could we look into the substance, or could we examine the compliance of the measure with Article 2? Would that be within our terms of reference? Can we do that?
Madam Panelist, we believe that for the objective assessment of this claim, the panel may consider the arguments why the carbon charge is other duties and charges. However, the panel isn't in a position and does not have jurisdictions to make findings whether the carbon charge is compliant with GET Article 2.1b.
As a result, there will be an aspect of the measure that the panel cannot examine.
Of course, we believe that that the panel cannot make findings under GET Article 2.1b, and the claims will be dismissed. And with respect to...
Sorry, Counsel. So you refers to Article 1, second paragraph, to say that the measure is an internal measure because it's for goods placed on the market. But then when you look at Article 3.1, little 1, it seems that the tax, what triggers the tax, for domestic good is the production of the goods, but for imported goods is the importation. Isn't that something we should take into account? Because if it's linked to our importation, according to the test you gave us, then the measure should fall under Article 2 and not Article 3.2.
And just to follow up on that and give added context, from my understanding of the facts, the charge is administered based on information received from the customs authority, and that the customs authorities cannot authorize the import of the product until the producer has paid the carbon charge. So just another point that goes the other way in terms of our characterization of it as an internal or border measure.
Of course, Mr. and Madam Panelist. First of all, we would like to say that we believe that these peculiarities of the procedure which are connected with the importation are only administrative ones, because we know that there is add note to get Article 3, which says that even internal taxes may be collected at the border. Moreover, we believe that placement on the market is a broader notion than importation itself, because before the products are placed on the market, they have to be imported. But not all imported products are placed on the market, because, for example, they may be stored somewhere near the border and never placed on the market. Moreover, with respect to greenhouse gases emissions, that respondent also may suggest it is the factor triggering the obligation to pay the carbon charge. We believe that this argument does not work because emissions take place both in Ruthenia and other countries. And moreover, Burundian producers are not paying for their actual emissions, but according to 5 worst performing installations rate, meaning for the emissions of 5 worst performing Ruthenian producers.
So just to clarify, earlier you said if a product is stored somewhere along the border, it is not placed in the internal market.
Yes, Mr. Panelist, we believe so.
Okay.
And with respect to our second criteria, that is application both to domestic producers and importers, we once again invite panel's attention to this Article 1, namely to the second part of this sentence, which says, and I quote, goods placed on the market in Ruthenia, whether of domestic or foreign origin. Hence, carbon charge applies both to domestic producers and importers. We see that the two criteria are satisfied, and that's why the complainant believes the carbon charge is an internal tax falling within GET Article 3.2. But in anticipation of respondent's argument that carbon charge is other duties and charges, we would like to comment on this. Namely,
So I think the panel is satisfied on this issue. Could we perhaps move to the likeness criterion?
of course. And the second argument under the first sentence is the likeness analysis that requires us to look into the end use, consumer tasting preferences, physical characteristics, and tariff classification. And we will start with end use.
Counsel. These are indeed the factors that you would look at in order to determine likeness. But I've got two questions. Why do you look at these factors? Obviously, to determine whether products are like. But what is that to determine whether products are like? That's the first question. The second question, are the factors that you listed, is that an exhaustive list? Or could we, for example, also look at the price difference between the products at issue?
Of course, Mr. Panelist, if we're speaking about GET Article 3.2, we know that here the likeness analysis is the narrowest one. And that's why we believe that all those criteria shall be analyzed in order to understand where the products are that similar in order for the requirements not to be taxation in excess. And for the, would you?
That's not an answer to my question.
And we believe that those criteria are important in order to look into.
Why do you look at these things? Why do you look at product characteristics? Why do you look at tariff classification? Why do you look at end use? Why? In order to determine whether products are like, yes, we know that. But what is it that you're actually doing by looking at these elements?
We need to establish that they are competing on a single market.
And so maybe let me rephrase on behalf of my co-panelists. I think what he meant is why are you looking at these specific factors, but not the other factors?
Yes, we understand, Mr. Panelist, and we believe that we need to establish that the products are competing on the same market, and that's why we look into consumers, into end use, in order to understand that they are bought by the same industrial consumer as in our case, and they are used for the same purposes on the market.
You used the central word. Determining likeness is determining the nature and the extent of the competitive relationship between the products.
Yes.
That's the thing that, but you refer to competition. That's good.
Yes, Mr. Panelist, and answering to your second question, whether this list is exhaustive, we understand that this list isn't exhaustive, and sometimes panels also take into account, for example, pricing, PPMs as part of the consumer taste and preferences analysis, and etc.
You said PPMs can be part of consumers' tastes and habits. Can PPMs be a separate criterion in the analysis of likeness? Because you just said that the list is not exhaustive.
Madam Panelist, as far as we understand, production methods are usually and often, I would say, analyzed within consumer taste and preferences. And all cases we are
In which
aware-
cases have they been analyzed?
EC asbestos, for example, also EC palm oil case, and Canada renewable energy, I would say.
If we were to decide that we want to make it a separate criterion, could we do that?
I believe so. It is for the panel, and this list isn't enshrined in GET and may be developed by the panels.
Can I ask a question about that, and not to take us too far down a rabbit hole? Is that a factual or a legal characterization? So if we were to add, this panel were to add a new criteria separate and divorced from what has been done before, not as part of consumer preferences, but PPMs on its own, add that criteria for consideration. Would that be something, one, that's a factual or legal characterization? And what is the possibility for a review of that if a higher body were to decide that they didn't agree with that added dimension, that added criteria?
Madam Panelist, first of all, we would like to say that we believe that it is legal interpretation of the term of likeness under GET Article 3.2, and then the report will be adopted, and all countries will make the assessment whether such interpretation is correct or not and adequate and satisfies the requirements of GET Article 3.2. And we believe that it is plausible because production methods have been already analyzed a lot by the panels, and determination as a separate criteria would not change the nature and the scope of the analysis of the panel. And moving to likeness. First of all, we believe that there is the same end use of the glass on the market, namely DiEM buys all this glass and uses for the production of furniture, kitchen appliances, and decoration. With respect to consumers, the complainant points out that there are two types of consumers in the present case, namely industrial one, that is DiEM, and ultimate one, that is Ruthenian population. And we, as a complainant, understand that Ruthenian population is eco-friendly and cares a lot about climate change, but in reality, on the market of glass, Ruthenian population cannot differentiate between more and less carbon-intensive glass, since Ruthenia introduced no labeling and glass is blended by the industrial consumer.
Excuse me, Council. So you mentioned two types of end users here, but which one should we look at? Should we look at both, or do we only consider that one is relevant? Because I assume your co-counsels will argue that the population is more important. How do we resolve that issue?
Mr. Panelist, we believe that population is important. However, in this case, we could not have any evidence how Ruthenian population reacts on more and less carbon-intensive glass on the market. And for these reasons, we should look at the industrial consumer. And here, we believe that the most reliable data on the preferences of the industrial consumer is dated 2021, before it was influenced by the measure, that is carbon charge. And we see that in 2021, DiEM bought most of the glass from Berlandian producers, and that is their true preferences. And for these reasons, we believe that DiEM is guided by profit and therefore do not differentiate between more and less carbon-intensive glass. And now,
Also, why was this regulation introduced in the first place? Wasn't it because of the population in Ruthenia really prefers environmental friendly products? That is why they voted in the Green Party, which introduced this legislation. How could you say that we would then disregard the preferences of the end users, the human consumers, and only take into account the preference of the industrial consumers or users?
of course, Mr. Panelist, first of all, we we fully admit that we need to look into the preferences of the ultimate consumer, but not in this particular case. Moreover, we believe that if Ruthenian population differentiated between more and less carbon-intensive glass on the market, no measure was needed. And if Ruthenia introduced this measure, they would have introduced also labeling in order to their consumers.
But why would no measure is needed? I mean, they would need, because the consumers do not have a PhD degree in chemistry and so on, so they would need the industrial producers to, choose for them. And that is why the regulation was introduced in the first place, isn't it?
Mr. Panelist, we believe that the measure was introduced in order to artificially shift the industrial consumer, of course, but however, we believe that industrial consumer does not differentiate too, but it is only guided by its profit consideration. We see that back.
Well, they might not want to differentiate on their own, but that is the purpose of the law, right? To force them to choose more environmentally friendly ones, even if that is not their original preference.
Yes, Mr. Panelist, but unfortunately, this leads to excessive taxation of Burlandian producers, such construction of the measure. And it is further indisputable in our case that flat glass from Burlandia is like to flat glass from Ruthenia in terms of tariff classification and physical characteristics. For these reasons, and I would like to state pardon for as to the production methods, and here we believe that carbon intensity that do not leave trace in the final product, that is glass, cannot testify against likeness. For these reasons, the complainant believes that Ruthenian and Burlandian flat glass is like. Mr. Chair, could I please have 2 more minutes to conclude my presentation?
Yes,
Thank you.
that's fine.
And now we are moving to our third argument under the first sentence, and that is excessive taxation. We would like to remind that there is no de minimis standard, and any discrepancy in taxation is enough to constitute violation. And first of all, we would like the panel to look into the administration of the measure. And here we invite your attention to Annex 3 of our case. It's footnote 7 and page 14. Here we see that carbon emissions may be determined based on one of the following methodologies, namely calculation-based, that is based on the activity data, and measurement-based, that is direct measurement of emissions. We see that those methodologies are alternative, so it was plausible for Burlandian producers to provide calculation-based information because they are aware of the amount of the fossil fuel used, the amount of glass produced, and even Carbon Watch may provide information as to their actual emissions. But however, in July 2023, Ruthenia changed the procedure that can be found in implementation regulation in clarification question 87. And in these regulations, those two types of information became cumulative. That is, now Burlandian producers are supposed to file both calculation-based information and measurement-based information. And I quote, the monitoring and calculation of embedded carbon emissions.
Council, I hate to interrupt you. You have little time left, but you're referring to the administration of this measure. Could you not have made a case under Article 3.4 of the GATT? Or is that completely impossible? I know you haven't made that case, but I mean, could you have made that case?
Mr. Panelist, we believe so, that the verification and the monitoring procedure as laid down in the implementation regulation and Net Zero Future Act can fall within a separate claim under GATT Article 3.4, but we believe that in this case, in our circumstances, those verification procedure can be regarded as violation as such.
You have any case law to refer to?
How many times? Unfortunately, my time is up, and I believe my co-counsellor will cover excessive taxation. Thank you for your attention.
Good afternoon, members of the panel. My name is Alexandra Mikhailova, and for the next 14 minutes, I will continue the presentation on behalf of the complainant. First, I will address the inconsistency of the exemption and deduction under GATT Article 1.1. Then, I will proceed with showing how exactly Article 21 cannot be used in the present case.
Sorry, were you going to continue on from the arguments, or are you just starting a new Article 1 argument here?
Of course, Madam Panelist. In fact, I wanted to point out that before I move with my main presentation, I will conclude on our claims under GATT Article 3.2. And in regards to the excessive taxation, we submit that, in fact, the difference in the taxation is twice as big, because if we compare Vetro's carbon charge, it would be around 6%, almost 7% of the price. Meanwhile, Guta's carbon charge will be only 3.23% of glass price overall. And therefore, we submit, because of that, the measure leads to excessive taxation.
What if we're not with you on the first sentence? Are you making any arguments on the second, or is there any, I wouldn't go through everything again. Is there any specific point you'd like us to take into account for the second sentence, or you're just making claims under the first?
Of course, Madam Panelist, we claim that if the panel isn't satisfied with our argumentation on the first sentence, then at least second sentence can be seen as relevant in the present case. And for that, the main point is actually to prove that imposition of carbon charge is in order to afford protection to domestic producers. And for that, our arguments will be as followed. That firstly, in fact, exports even is in charge in Ruthenia, meaning that only those produced of flat glass in Ruthenia that are going for import would be priced, meaning that the measure isn't even pursuing its own objective. Furthermore, our next argument that they, namely Ruthenia, were preparing their domestic producers, at least from 2017, when subsidies was introduced for the renewable energy. And also our third point, we could see clearly from the statement in paragraph 11 of Mrs. Rada Strong that they acknowledge the fact that introduction of carbon pricing wouldn't disadvantage them via these foreign competitors. And with all those arguments, we submit that GATT Article 3.2 second sentence was violated by the introduction of the carbon charge. And now, members of the panel, moving with my main presentation, namely under GATT Article 1.1, we submit that both exemption and deduction violates provisions of most favored nation treatment obligation under GATT Article 1.1.
1 second, I believe one of our panelists who is joining remotely would like to ask a question as well.
Sorry, Councillor, could you please clarify just very quickly, which products are you comparing for the purpose of this claim? So Article 3, which are the products that you are comparing? Domestic, when you refer to domestic and imported, is imported limited to Borlande or the group of imports in general?
Of course, Madam Panelist. In fact, we compare Borlandian products that were at disadvantage by the introduction of the measure and domestic producers, because we acknowledge
which domestic producers? All domestic producers or just Guta?
We have all the information on Guta, and because of that, we compare Gutas and Vetros.
Are you sure we don't have information on other producers? Because, I mean, you have default values in these measures that are calculated on the basis of the 5 worst performing domestic producers in Ruthenia. So we do have information about other producers. I mean, Guta is a big producer, but it's not the only domestic producer there. There are other producers which are being charged exactly the same tax than you are, the default values. So why is the measure affording protection to domestic producers in general when a bunch of them are applied exactly the same tax than you are?
In fact, Madam Panelist, we consider that despite the fact that we know about 5 most performing installation rates, you indeed true that we have this information. Nevertheless, they are charged in such a way that they pay for their actual emissions, as well as those 5 worst performing installations. Meanwhile, importers, and we know for importers from Burlandia, we know only information for the Vetro, they pay more than they actually emit. And it's exactly the problem with carbon charge. And now, moving with the GATT Article 1.1, I will first show you how exactly the exemption measure violates the provisions of most favored nation treatment obligation under GATT Article 1.1. And for that, we submit that firstly, the measure is covered under GATT Article 1.1. Secondly, that it creates an advantage. Thirdly, that the products are not alike, and also that finally an advantage is conditional. As to the coverage, we are looking into both exemption and deduction measure, primarily because they are derivatives from the carbon charge that my co-counsel, Ms. Yulia, has already shown is covered under GATT Article 3.2. And consequently, they also covered under GATT Article 1.1 as derivatives. Moving further, as to the creation of advantage for exemption measure, we submit that there is 2 types of advantages granted. Firstly, the exclusion of payment from LDCs and seats, and precisely Artania, and also the exclusion from administrative burden of submitting declarations. Moving further, as to the likeness, for the sake of exemption, we can presume...
Are these claims of discrimination de jure or de facto?
First of all, it is de jure because we could see from how the measure is designed that it provides an advantage to some countries. But if the panel doesn't find such a case...
Counsel. What is a de jure violation?
De jure...
Because I'm concerned about the definition that you just gave.
The jure violation is violation that could be seen on its face, like in the present case, from how the measure is crafted. And when we talk about de facto violation, it's in the cases if we do not found a de jure violation, meaning on its face the measure is non-violative, but in its application, it's in fact violates.
But discrimination as it relates to what exactly? For purposes of Article 1, discrimination relating to what?
Discrimination relating to the equity of competitive opportunities for like imported products, in the present case from Burlandia, and for the sake of exemption measure from Artania. And we believe...
Counsel, just to be very clear, are you arguing that both the exemption and the deduction are de jure violations? Or are your claims different with respect to these 2 aspects?
No, both exemption and deduction are de jure violations. And because of that, members of the panel, if we look exactly at the exemption measure, we could see that the likeness can be presumed as the only criteria that established for differentiating sunflower grass from other is based on its origin from LDCs and seeds.
Counsel, is your likeness test, I seem to like likeness, is your likeness test under 1.1 different from the one that you applied under 3.2?
Of course, Mr. Panelist, because in fact, under GATT Article 3.2, there is the narrowest way for implementing the likeness. If we compare it, for example, with GATT Article 1.1, because we're talking about the taxation, that they need to be at the very high threshold. But for the sake of GATT Article 1.1, they still need to be perfectly substitutable, but the threshold, in our opinion, is not that high.
So, given the fact that you've made your argument under 3.2 first sentence on likeness, you can now immediately move on with regard to likeness under 1.1. correct?
It is correct, in
Yeah,
fact.
please do so.
Of course, Mr. Panelist. So if the panel isn't satisfied with the presumption of likeness, our stand on the likeness presented by Ms. Yulia is still holds for exemption and deduction. Even so, the countries are different, the types of the products are still the same. And moving further as to the conditionality of the measure, the fact that only countries with a certain status could receive an advantage in itself is a
Excuse me,
conditionality.
Council. Talking about the advantage, when we look at the deduction element, is there really an advantage? Because if you look at the total charge paid on the product, it's the same because there is already a charge paid in the country of origin. So can we really say in that case that there is an advantage?
Mr. Panelist, moving forward with my presentation as to the deduction measure, in fact, we submit that advantage exists because implicit carbon pricing wasn't considered. It means that in the end, while Corsania pays 50 USD per CO2 ton in total, our producers pay 65 USD per CO2 ton, which creates this advantage. And we will address it later. But as to the conditionality of the exemption that we were discussed earlier, as we see the condition exists, this condition also have detrimental impact on the competitive opportunities of like imported products.
Council, to help you possibly, of what relevance is the fact that there are subsidies being provided in Ruritania to, I imagine, the production and will reduce energy, et cetera? How do we take that into account in considering whether the conditions being given in the various countries are actually the same for purposes of the advantage analysis?
In fact, even though the conditions of the countries from the beginning are not the same, for the sake of Ruritania, their existing subsidies, in fact, doesn't play a role for the analysis under GATT Article 1.1. We still submit that consideration of those conditions are not perhaps this relevant for the GATT Article 1.1. And we consider how the measure in itself creates this advantage and not what was before establishment of this advantage. And
so to go back to the exemption, I understand that the Paris Agreement recognizes the special status of LDCs and SIDs. And Ruritania imposed the measure in compliance with those obligations under the Paris Agreement and to help LDCs and SIDs. Do you argue that we should not be looking at all at what the Paris Agreement says and just side with your seemingly narrow interpretation of Article 1 of the GATT?
Madam Panelist, Mr. Chair, could I have 2 additional minutes to conclude? Thank you. Answering Madam Panelist. Thank you. Answering Madam Panelist's question, in fact, we cannot consider our obligations that beyond WTO agreements, at least only to the point that they do not contract out from the WTO agreements. And because of that, we can only use in the present case Paris Agreement as a means of interpretation under Article 31.3 of PCLT.
What exactly would we be interpreting? Which terms could we use the Paris Agreement for interpreting?
For example, my co-counsel, Ms. Elizaveta Pogrebnyak, will address it by the analysis of the GATT Article 20 when considering conditions that exist in those countries, in different countries. And with that, we submit that...
Excuse me, Council, I have a follow-up question on what my colleague asked. So you are challenging the exemption of the LDC and the price reduction. In terms of implementation, if you were successful with bringing this case, how would you like to see the measure being amended after the panel ruling?
In fact, we believe that Nether Refugee Act have a complex problems, and because of that, in order to bring it into compliance, we will see that the only way is either to withdrawal of the measure or complete modification. Which
in which way?
Complete modification of which points that we address, namely both with deduction, exemption, and with problems with the present 5 performing installations rates and other. And Now, concluding to why exemption measure condition leads to violations that have detrimental impact, its effect that the only way Artania's sales of flat glass increasing is at expense of Burlandian decrease, which could be seen from the Annex 4. And now, in conclusion to the deduction measure, we already discussed why advantage exists, and because of that, Mr. Panelist also addressed that we could address the likeness as Ms. Yulia has shown, and because of that, we only will address the conditionality. And the fact that, again, only countries with explicit carbon pricing receive an advantage is the condition that is in fact prohibited by GATT Article 1.1. Because if we look at the existence of implicit carbon pricing mechanism in other country, Burlandia, it wasn't considered, despite the fact that firstly, it pursued the same goal, and secondly, it is possible to recalculate to 15 USD per CO2 ton. And with that, we submit that GATT Article 1.1 was violated by the introduction of both exemption and deduction. Thank you.
Thank you.
Good afternoon, members of the panel, Mr. Chair. My name is Елизавета Pogrebnyak. Within the next 13 minutes, I will conclude addressing issues on behalf of the complainant, Burlandia. In conclusion of our submission, I will demonstrate that Net Zero Future Act measures are not justified under Article 21b, subparagraph 3. Secondly, these measures are not justified under Article 20 of the GATT. Members of the panel, we admit that the definition of emergency as to Article 21b, subparagraph 3 has been expanded recently. It now includes the samples of terrorism. However, we submit that the threshold of emergency is still too high for climate change to be seen as the emergency.
Council, before you go any further, do you agree that greenhouse gas emissions and their effect on the global climate are an existential threat to life on Earth as we know it? Do you agree with that? And if you do agree with that, are you seriously arguing that the climate crisis is not an emergency in international relations? Do you think, and I assume that you're going to refer to the panel report in Russia Traffic and Transit, do you think that the definition that the panel gave to the concept of emergency in international relations does not include this sort of existential crisis?
Mr. Panelist, we see your concern as to the excessive emission of carbon dioxide. However, we submit that in terms of Article 21, emergency in its impact should include the tensions of the gravest possible nature and the clash between the states in this regard. Again, referring to the case Russia Traffic in Transit, the only adopted report. However, there are other unadopted panel reports, namely Saudi Arabia intellectual property rights case, US origin marking, US steel and aluminium products Turkey. In all these cases, the clash between the states were present, and the combustion of international relations was due to this clash. However, in the present case, carbon dioxide excessive emission is not intentional for the purpose to injure or to harm other states.
So does your argumentation presuppose that there is nothing that can be done about climate change until there is an actual breakdown in international relations and when we are at the point of no return?
Madam Panelist, in this regard, we should remember that Article 21 is not for the future projection, since there is the requirement taken in time of and contrary.
And is it your argument that the climate emergency is not currently ongoing?
Madam Panelist, we submit that climate change could not be regarded as an emergency in international relations, though the repercussions are present. However, in the analysis of Article 21, we would like to submit two arguments. Firstly, there is no emergency in international relations.
Counsel, before you go into the depths and the weeds of this, is there a certain posture that this panel must take in how it interprets this provision generally in terms of the standard of review? Is it that we defer to countries in their own articulation of what is an emergency, especially in light of prior case law? You mentioned case law that was unadopted. To what, how should we view that unadopted panel report? And how should we take it into account in our own deliberations?
Madam Panelist, though unadopted panel reports are unadopted, as it was stated in Japan alcoholic beverages case, we may refer to them to whenever the ratio are relevant. Therefore, we may use the argumentation in these cases. Moreover, we would like to point out that the provisions of Article 21 are not self-judging. As it was stated in Russia traffic in transit case, states may have capacity to determine their own essential security interest. However, this determination must be done within the principle of good faith. As to our argumentation under Article 21, pardon, Mr. Panelist.
No, you do.
Given that this is a very political question you are asking us, and we see some tension in it, could this panel decide to declare a non-licet, to not rule on the issue, or do we have to decide whether Article 21 is applicable in this instance or not?
Mr. Panelist, as it was done in Russia traffic in transit, panel also argumentated whether Article 21 is applicable, and our primary position is that it is not applicable in the present case. Moreover, as to our argumentation as to non-existence of emergency, we would like to point out that the impact of climate change is incomparable to the impact of war and our conflict. In this regard, we rely to the findings in US steel and aluminum products Turkey. And in this case, it was stated that the ultimate expression of emergency in international relations is the existence of tension of the most serious and gravest nature. However, in the present cases, we may see the tensions between Artanian population and Ruthenian population were only occasional and not regular, and they were not of that serious nature.
So may I point out that paragraph 13 of the case says that there has been a UN Security Council meeting which debated the issue of sea level rise and implications for international peace and security. You don't call a UN Security Council meeting lightly. So does that not point to us that there is actually a grave international emergency? And in previous cases that you have referred to, the emergency was more of a bilateral character. So perhaps the case law that you are citing is not that relevant in this situation where we actually have a global emergency, and perhaps the standard that this panel should be applying should be different.
Madam Panelist, we see your concern, but before answering to your first question, in the same paragraph 13, we see that several United Nations members stated that they are concerned over the counterproductive securitization of climate change. And moving further to paragraph 16 of our case, which is on the page 6, it is stated that the United Nations General Assembly resolution as to the advisory opinion of the ICJ is still pending. Therefore, there is no consensus in international relations as to the existence of emergency in international
relations. Do we need a consensus? The report in Russia traffic in transit, there are members of the Security Council who would not agree that there is an emergency in international relations going on, and yet a WTO panel decided that there was one.
Madam Panelist, in this regard, we refer to the temporal factor that the ICJ advisory opinion is still pending, and therefore...
Should we wait until the ICJ decides?
No, of course not. However...
What's the question before the ICJ, and what is it about whether there's an emergency or not? Why do we need to wait for that determination to call this an emergency?
Madam Panelist, the existence of emergency in international relations is subject to the objective determination, and we may rely to the facts in the present case. However, our next... Yes, Madam Panelist? I guess remotely.
Thank you. So just to be clear, what you're trying to argue, for you to consider we are facing an emergency in international relation, we basically need to wait for Artenia to disappear from this planet.
No, Madam Chair, we are not arguing that there is a need to disappear for Artenia to constitute emergency in international relations.
So
However,
are you arguing that climate change or the climate crisis will never amount to an emergency in international relations, or that the threshold is not met? And if it's not met, what do we need to wait for? We need to wait for a couple of seeds to disappear from the planet, for more people to die in order to consider it an emergency in international relations?
Madam Panelist, we submit that the nature of climate change does not consider the emergency in international relation in the ordinary meaning of Article 21b subparagraph 3, since the ultimate goal of this article was to prevent the transfer of ammunition, fissionable materials, meaning that it relates solely to the war and armed conflict.
Sorry, can you remind us when Article 21 was drafted?
It was drafted in 1947.
That's correct. Was climate change an issue then?
No, it was not.
Is that relevant to our consideration, or could we interpret Article 21 in light of the contemporary concerns of the international community?
Madam Panelist, we submit that evolutionary interpretation may take place in WTO. However, in regard to Article 21 and 20, we submit that would inevitably lead to the opening of Pandora box, since every state would try to justify their measures under the umbrella of security exceptions. And that is why it is not possible.
So isn't that our very job here, to make that determination? Which are the factors to be consideration, and not making it a limitless obligation or right, but kind of creating the boundaries that are deemed to be acceptable for purposes of international relations?
Madam Panelist, in this regard, we would like to refer to Article 3.2 of the Dispute Settlement Understanding, with the view that there should be no adding or diminishing of the rights and obligations. And moving further as to—
Excuse me, Counsel. You mentioned that if we agreed with your colleagues, this would be opening Pandora's box. What would be the risk for us to actually consider that climate change could fall under essential security interest and could be an emergency in international relations? What would be the implications both for the trading regime, but also potentially outside of it for the broader context of international law?
Mr. Panelist, we see that the inclusion of climate change within the scope of Article 21 in general would lead to that every state would try to justify all the violations of the GATT according to the protection of their essential security interest. And we think and are definite that this change would only lead to the combustion of the trade relations in international relations at all.
So I'm sorry to interrupt. One more question. If climate change is not covered by the scope of an emergency in international relations, what kind of concerns, except an armed conflict, would, in your view, be covered by that provision?
Madam Panelist, we submit that, before I answer, may I ask for 2 additional minutes, please, Mr. Chair? Thank you.
Yes,
yeah, thank you. In regard to understanding of subparagraph B3, we see that this is war, armed conflict, terrorism, or other emergencies that include clash between the states. I see the comment of Madam Panelist. May I move to Article 20 to conclude?
No.
No.
Because when I referred in the beginning to my question about the definition given in Russia traffic in transit of what an emergency in international relations is,
May I quote?
it goes further. Look at the end of that
yes,
definition.
I may quote, it was stated in paragraph 776, and I quote that emergency in international relations refer to armed conflict, latent or ongoing, heightened tension or crisis, or general instability engulfing in the region. However, in the next sentence, it stated that this factor should give rise to war and defense-related matters, and climate change neither implicitly rely to these factors. And With permission, may I move to Article 20 of the GATT? Members of the panel, we submit that Net Zero Future Act measures are not necessary, since Net Zero Future Act measures do not meet the requirements of subparagraph B and do not satisfy the conditions of the chapeau. As to the subparagraph B, we submit that Net Zero Future Act measures are not necessary, since there are existence of standalone, less trade restrictive, and more contributive alternatives in this regard, namely international cooperation and climate assistance under Article 4.5 of the Paris Agreement. And we deem that this is a complex alternative, which would couldn't exist simultaneously with Net Zero Future Act. As to cooperation, we submit, relying to appellate body report in US shrimp case, that cooperation is deemed as the best and the most effective method.
So a quick question. It takes years to reach international cooperation. So what should we do in the meantime? How realistic is this alternative?
Madam Panelist, we deem this alternative as realistic, since every state in this region introduced nationally determined contribution. Therefore, they are determined to combat climate change and to reverse its repercussions. And therefore, we deem it is feasible. For the time efficiency, we submit that we would like the measure to be brought into conformity according to Article 3.7 of the Dispute Settlement Understanding. Thank you.
Thank you, the panel. Thanks the complainants for their arguments. And now we turn to hear the respondent.
Good morning, it's afternoon. Good afternoon, members of the panel. As stated, my name is Mark Gitau, and I will begin by arguing that Articles 4 and 5 of Section 10 of the NZFA are consistent with the MFN obligation under Article 1.1 of the GATT. We agree with the test laid out by the complainant, and we will contest two ambits of this test. First, that the products under consideration are not like products, and second, should the panel find that they are like products, the advantages accorded by Articles 4 and 5 have been accorded immediately and unconditionally. Turning to the second element in the order of examination, Counsel for Complainant raised a presumption of likeness under the Article 5 claim based on discrimination on origin. While we agree that such a presumption can be made under Article 1.1 of the GATT, it is our submission that Article 5 of the NZFA does not discriminate based on origin, as this measure is based on the developmental status of countries and not where they originate from. And therefore, this measure is not de jure or de facto discriminatory.
So could you please explain to us, I understand that the list of LDCs and SIDS is a closed one, at least at a certain given point in time. So why would that not be origin-based discrimination if we have a defined list of countries who can benefit from the exception?
Madam Panelist, that will not still be discriminatory given that in previous panel and appellate body decisions, the reasoning has been that the measure is origin neutral when it doesn't explicitly state the countries. In Colombia, Portoventi, for example, it was Panama explicitly stated in declaring an advance import declaration. However, even if the panel were not persuaded by the fact that the country has to be listed, it is our submission that the list of LDCs.
Counsel, do you only have de jure discrimination if the measure explicitly refers to a country, or may also have de jure discrimination when by implication, by necessary implication, there's a reference to a particular country?
Professor, no. De jure discrimination happens when there is explicit reference to countries. If there is no explicit reference, but there is still effective discrimination, then that becomes de facto discrimination.
So Counsel, if I were to say that a country that will be benefit from a certain measure has 2 pitons, is surrounded by water. I'm of course talking about my own country, St. Lucia. And I did everything to describe it, and that the benefit was going to go to a country with these features and of a certain GDP per capita, and I didn't name St. Lucia in the measure, it wouldn't be de jure?
That's a complex question.
Is it
Madam Panelist. It
I
is
mean,
still up for-
that's how your argument is going. So tell me why that would not be a logical implication of what you're arguing.
Dr. Remy, the distinctions between de facto and de jure exist because de facto is meant to help the panel determine discrimination when a country is using a condition so as to avoid the MFN obligation. And thus, in that kind of situation that you have described, there is certainly no country listed, but it is evident that that country will be trying to avoid the MFN obligation, so it will still be de facto discrimination.
So you're looking at the intent, you're actually looking at the intent of the country in the determination of discrimination or the effects?
It is the respondent submission that you should look at both. And we understand that Article 1.1 is a no intents and no effects test. But what we understand this to mean is that the treaty text does not require the panel to assess the intention of the respondent or the trade effects of the measure. But this does not mean that the panel cannot assess these ambits of evidence. And I will address your concerns on discrimination on the last element of the Article 1.1 test. For now, I would like to proceed to the consumer taste and
I
habits
think we may have a question from our panelists joining us remotely.
Thank you, Chair. Yes, I was going to ask you to, in the case of the exception, to please, assume in arguendo, we agree with you that there is no origin-based presumption of likeness that can be made in this case, whether you can still explain to us why imports of flat glass from Burlandia and imports of flat glass from Ruthenia are not like, in your view, given that they are both highly carbon intensive.
I beg your pardon, Professor Duran, did you say Ruthenia? Burlandia and Ruthenia?
Burlandia and Artenia,
Oh.
the LDC seeds, yeah, which is the one concerned with the exemption, yeah, under Article 1. So you compare in Burlandia and Artenia here, yeah, the LDC seeds, yeah. Both are exporting flat glass to Ruthenia that is highly carbon intensive. So there is no discussion here about difference in ppms and so on and so forth. Why are the products still not like, in your view?
Thank you, Professor. And this is a perfect segue into my likeness analysis. The short answer to your question is that the consumers in this matter are two consumers, and their preferences are with regards to the carbon intensity. And the carbon intensity from Burlandia and Artenia is not the same. And it's not the same given the fact that Burlandia's capacity to manufacture has been higher than Artenia's. And thus, every year, the Burlandian flat glass products have been diminishing, so has the amount of carbon embedded in the products. And this is
So
relevant.
do I understand correctly that you're looking at the overall amount of emissions, but not at the amount of emissions per ton?
Yes, Madam Panelist.
Why would we be looking at that? Isn't a more objective way to compare is to look at the amount of carbon emitted per ton of product produced?
Yes, that is certainly a more objective way. However, in this case, the only evidence we have of consumer purchasing behavior, which is what should be assessed under consumer tastes and habits, is that under Annex 4. And we cannot assess what is in the consumer's mind regarding the objectiveness of the carbon intensity emanating from Artenia and Burlandia. All we can see from the data in Annex 4 multiplied by the carbon emission rates in paragraph 7, 8, and 9 is that the overall amount of carbon embedded in the products is declining despite the fact that the amount of products from Artenia is increasing and the amount of products from Cosenia is also increasing. So this suggests that the consumers, the immediate consumer DIM, is actually strategically aligning with the preferences of the ultimate consumers. And in this case, it is our submission that the preferences of the...
Sorry, Councillor, are you saying that the facts of the case reflect that the carbon intensity of imports of flat glass from Artenia is lower than Burlandia? And if that is your argument, where is that in the case? And secondly, are you submitting that these products are not in a competitive relationship on Ruthenia's market? And if that's your argument, what's the supporting fact in the case for that?
Certainly. With regards to your first question, it depends on what we understand carbon intensity to mean. The respondent is using carbon intensity here to mean the I retract my earlier statement when we said the amount of embedded carbon emissions. What the respondent is trying to say when he say carbon intensity is what is reflected in the facts, that they are using 0.70, that Atenia is using a rate of emissions of 0.70 per ton of CO2, per ton of glass produced, and that of Burlindia is 0.65. However, when we talk about embedded carbon emissions, what we mean is that this is being the total of carbon emissions from the quantum of products being imported from each jurisdiction. So we are multiplying the rate.
Is that how you define embedded emissions in your act?
No, Madam Panelist.
Well, then you should follow the definition in your own measure, I believe.
The measure only focuses on the amount of CO2 that is emitted per ton of glass, which is the definition. And what we are arguing is that the evidence under Annex 4 demonstrates when multiplied with that carbon intensity that you have cited, Madam Panelist, will show that the overall total of CO2 in the glass products coming into Rutinia is reducing every year. And this shows that even though we cannot determine the exact purchasing behavior of the ultimate consumers, there is something to be said about the immediate consumer strategically purchasing products such that every year the amount of carbon emissions embedded in the glass is reducing. And this will answer your second question to show that there is a weak competitive relationship between the products on account of the fact that it is solely because Burundian products are being purchased less that the products' embedded carbon emissions are reducing. However, if the panel was still not satisfied, Madam Polovets, I note you have a question.
I'm still not satisfied. I have one question. Is there any direct relevance in the case showing that the final consumer, that is physical persons, citizens of Rutenia, actually somehow care about the carbon emission when they buy the final product, a piece of furniture? And is there any way for them to know? Because the complainant told us that the final consumer cannot tell how much CO2 was emitted in the production of a certain product. So how can we make that presumption on the basis of what? That the final consumer has a certain preference and that that preference drives the decisions of the intermediate consumer?
Thank you. The first question on the direct evidence, the answer is no. There is no direct evidence on this. And the second question on the basis of the presumption, we rely on the conclusions of the appellate body in EC asbestos. And we know that this is controversial given that in that case, the carcinogenicity was in the products themselves. However, the appellate body in that case did not have any evidence of the ultimate consumers as well. What they looked at was a real market and an ideal market where consumers have full information and consumers make predictable decisions. And in this case, while we do not have in this real market the answers to the purchasing behavior of the ultimate consumers, in an ideal market, it will be expected that they will have preferences for sustainable products.
So in our analysis, Council, what are we looking at? Which market are we looking at? Are we looking at the Rutinian market, or are we examining some hypothetical ideal market when we decide?
Thank you. Mr. Chair, if I may request for 2 additional minutes to conclude.
Yes, that's fine.
Thank you. In this case, Madam Panelist, we will have to look at both. And the reason is that in the real market, we have evidence of consumer purchasing behavior for the immediate consumer and none for the ultimate consumer. And for the ideal market, we will be looking for evidence of the ultimate consumer. And I will now turn to the last element of
Excuse me, Council. Talking about the market, are we here talking about the market for glass? Are we talking about the market for the final product? And I think that will help us understand at which consumer we should look at, because it's not been very clear so far whether we need to look at the consumer of glass or of the final product. And if you have any either legal reasoning or a precedent that you could refer us to in that regard, that would be very helpful.
Thank you. Let me provide clarity. The consumer of glass, the flat glass products, is what should be considered. We only bring up the ultimate consumers because the immediate consumer cannot make purchasing decisions while ignoring the preferences of the ultimate consumer.
And what is your, let's say, legal reasoning for us to look only at the consumer of glass? Or do you have a precedent for that?
To be clear, Mr. Panelist, we mean that the consumer of glass should be considered for the purposes of consumer purchasing behavior. And the legal reasoning is that if there are sufficient risks involved, the immediate consumer's purchasing behavior will reflect or align with the preferences of the ultimate consumers as stated by the appellate body initials bestos. And in the last 30 seconds, members of the panel, I will now address that the advantages have been accorded unconditionally with two key statements. First, here we are talking about de facto discrimination, and the panel in Canada Autos determined that a standard for discrimination is considering the impact of the conditions and the context in which they were taken. Regarding impact, we cannot see any effect of the measures as there was already a decline in Burundian products from the year 2021 and 2022. And with regards to context, these measures were taken. Article 5 was taken to align with the Paris Agreement, while Article 4 has been taken to avoid double taxation. And I see that my time is almost up, and I will allow my co-counsel to proceed with Article 3. Thank you, members of the panel.
Thank you, members of the panel. Just to clarify, can I be heard? Thank you. I shall now begin on my submissions under Article 3, and under this matter, I shall respond squarely to the claims laid out by the complainant and argue that the charge in contention is not within the scope of Article 3.2, and if at all it is found within the scope of Article 3.2, that it is nevertheless not in violation of both the first and second sentences. Beginning with the first claim of the respondent in this matter, we argue that this charge, which is the NZFA's carbon charge, is not an internal charge, but rather an other duty or charge within the meaning of Article 2.1b, second sentence. Members of the panel, we note that the complainant has stated that the important factor of assessment is the triggering factor of the charge, which the appellate body in China Auto Parts explained to mean the factor that creates the obligation to pay the charge. And in this reason, we also note that they have noted that Article 1 of Section 10 of the NZFA states that the charge will apply to all products that are placed on the market within Rutinia. Members of the panel, we state that on importation of imported products within the NZFA's carbon charge regime are placed on the market upon their importation. And this is visible from clarification question 87. And as Mr. Panlist noted, in Article 3.1 of Section 10 of the NZFA. For this reason, we submit that for imported products, they are placed on the market at their importation. However,
so is the corollary of your argument that the measure will be an internal measure for Ruthenian producers and the border measure for Burundian producers, the same measure? It will be a different type of measure depending on whether you produce internally or import?
Madam Panelist, no, that is not the contention of the respondent. What we note is that the application of the measure between Article 3.1 of Section 10 of the NZFA and Article 3.2 of Section 10 of the NZFA create different obligations, in which the obligation under Article 3.2 applying on the complainant's products is an other duty or charge. However, the obligation applying on both imported and domestic products subject to Article 3.1 should be regarded as an internal charge.
What are the obligations that you are talking about?
The obligations that we're talking about are the charges that are imposed on the products. And we argue that there is a substantive difference in the application of the charge to products under Article 3.2 and those under Article 3.1. These being that the application of 3.1 and 3.2 are mutually exclusive. Secondly, that the requirements made on products under 3.1 and 3.2 are substantially different, in that 3.1 makes requirements of self-declaration. And finally, that the method through which this charge is imposed on the products is different, in that 3.1 requires calculation of actual emissions values by the National Tax Administration. And members of the panel, this interpretation is in line with the findings of the panel in EC-seal products. However,
So, Council, just to make sure that I understand, is it your contention that one and the same measure can never be both a border measure and an internal measure? Is that your contention? And if so, is there any case law that you could cite to back that up?
yes, Professor Van den Bosch, our contention is that not one measure cannot maintain dual legal characterizations, and the appellate body in China Auto Parts expressly stated this. However, what we are stating is that the application of articles of Section 10 of the NZFA's carbon charge creates separate obligations which need to be assessed differently by a panel as stated by the panel in ECCL products.
Oh, that the obligations are different, no discussion. But that in itself is not an answer to my question.
If Mr. Professor, if you would clarify on your question, I would proceed to answer it correctly.
No, I think I've heard what I wanted to hear.
But can I just elaborate on what my fellow panelists said? Are you saying that in fact, I thought I heard you say that in fact, the same measure, in this case under Article 3, could be construed for purposes of our interpretation as both a border measure, and when it's applied to both, it's an internal measure as well? So the same measure can be subjected to two different characterizations depending on whether at the time of the application of the measure, it's also applied to the domestic measure. I'm trying to understand what, I almost heard you say that you can do both. It falls under both a border and an internal measure.
Maybe if I can just add something to your question. If my understanding is correct, you said that if the charge is calculated under 3.1,
Yeah.
then it's an internal measure, but if the charge is based on the default value under 3.2, then it's a border measure. I think that builds on your question.
Yeah.
In answering your questions, members of the panel, I shall first begin with Madam Panelist's question. And we do note that what the respondent is stating in this matter is that we are not asking the panel to characterize the measure in contention, which is the NZFA dually. However, what we're stating is that the panel should consider that different obligations and consequently measures arise from this application. And the contention of the complainant, which is the imposition of this charge on their products, which is the respondent is stating is the charge under Article 3.2 of Section 10 of the NZFA, should be regarded as an other duty or charge. And responding to Mr. Panelist's question, yes, we are stating that the application under 3.1 is an internal charge and subject to 3.2 should be regarded as an other duty or charge. If there are no further questions, we shall respond to the...
Excuse me, Council. The difference between 3.1 and 3.2 is about how you calculate the tax, not so much about what triggers the tax, which is the test whether the measure would fall under Article 2 or 3. So I fail to see how the calculation element of the tax has an impact on the characterization of the measure. So if you could elaborate, that would be useful.
Mr. Panelist, even the application and the triggering factor of Articles 3.1 and 3.2 are different, because under Article 3.1, products are allowed continued market access up until the National Tax Administration will demand of self-declaratory values from its covered products. However, subject to Article 3.2, this charge will be imposed by the National Tax Administration upon placing of these imported products on the market, given that it is contingent upon determination of the 5% worst performing installations for the previous calendar year. Moving on to the second claims of the complainant, we shall address the element of taxation in excess of. But first, on the element of likeness, we shall rely on our co-counsel submissions in stating that the immediate consumers calibrate their purchasing based on the preferences of the ultimate consumers. Hence, the domestic Routinian products are not like to imported Burundian products. Under the element of taxation in excess of, we note that the complainant addressed the fact that imported products bear a higher charge than domestic products. However, members of the panel, we note that in conducting an assessment of taxation in excess of, the important factor is the assessment of individual import transactions between imported and domestic products. And for this reason, we see that on imported and domestic products, an equal effective tax rate is applied on all of these products, as each ton of embedded carbon emissions accrues the charge of 50 USD. Therefore, the application of the charge is equal and identical on both imported and domestic products. If the panel has no further questions, we shall move to addressing the respondents, certainly, Madam Panelist.
Sorry, Councillor, just to clarify, so you're saying that for the purpose of determining whether a product is taxed in excess under Article 3, we should look at the nominal tax rate rather than the actual tax rate? And if that is your submission, is there any case law that you could cite in support of that argument? So the 50, we should be looking at the 50, right? That's what you're saying, $50. That's the nominal tax rate or charge rate, yeah? Rather than the actual, yeah? How much you're gonna pay depending on the carbon intensity of the product that you are exporting. Is that your submission? And if so, do you have any case law that supports that we should be focusing on the nominal rate, the $50?
Madam Panelist, we note your contention that Article 2 of Section 10 of the NZFA prescribes this nominal rate of $50 per ton of embedded carbon emissions. However, we note that it is also not in our assessment of the application of this charge, the effective tax rate on a product's embedded carbon emissions constitute its actual tax burdens, as previous assessments of Article 3.2, taxation in excess of, have been conducted from referencing the findings of the appellate body in Japan Alcoholic Beverages 2. It compared the taxation of imported and domestic products as per the currency or the yen born per degree of alcohol content. And for this reason, this application on both imported and domestic products constitutes equal and identical tax treatment. Moving on to the second sentence, we will address the submissions of the complainant under the last element of affording protectionism to domestic production. Members of the panel, we note that the complainant has structured arguments on the elements of the subsidies offered to domestic production and the statements of Ms. Rada Strong. And we shall address these arguments as the role of governmental action in affecting trade figures within a domestic country. Pardon me, members of the panel. On this note, we understand that the element of Article 3.2 and the text of Article 3.2 protects the competitive opportunities offered to domestic and imported products. However, Article 3.2 does not constrict municipal governments from taking action in mimicking the interests of their consumers. Members of the panel, the government action of Routinia is based on the consumers which elected this Green Party into government, as is stated from paragraph 11 of the record. Further, members of the panel, we note that in Ms. Rada Strong's statement, this was a simple statement of fact. Given that domestic products have lower embedded carbon emissions, it is logical to presume that a product with lower embedded carbon emissions.
Council. Okay, we're under the fourth element of the Article 3.2 second sentence test. Are you arguing that the intention of the government, no matter how noble it may be, is of any relevance here?
Before I answer your question, Mr. Chair, would I request for 2 minutes to conclude on my submissions?
Yes, that's fine.
Mr. Panelists, we note that the role of government intention can be construed as protectionist intent. However, Mr. Panelist, this contention can only have claim if at all it does not mimic the interest of the consumers, as the consumers have the leeway to choose which products they would prefer in the consumption. Given that the consumers in Routinia chose the Green Party because of its agenda on reducing climate change, then any action of the government in wanting to choose greener products compared to products that are highly carbon intensive cannot be construed to be actions of the government in affording protection to domestic production.
But Council, aren't you confusing the means with objective? I mean, the consumers, the voters, of course, want the objective of green transition, but when the government enact these policies, whether or not they take a protectionist measure, that is a totally different issue. Don't you agree?
Yes, we note your contention. It may seem a different issue if the government takes this action in place of the consumers. However, we note that there is a direct causal link from the action of the consumers in wanting this government and choosing it based on its proposed agenda on climate change.
But that still doesn't answer my question. I mean, the voters want an objective. The government then carry out the objective by enacting some legislation, but it is no guarantee that this legislation would be consistent with its international obligations. They could do it in 1,000 different ways.
Certainly, Mr. Panelist, and on that contention, we state that it still does not violate the element of taxation of protectionist intent, because we note that this application on both imported and domestic producers is equal, in that all domestic producers would bear the carbon charge and all imported producers would bear the equal rate. Seeing that my time is up, members of the panel, my co-counsel shall conclude.
Thank you, members of the panel. Before I begin on my own submissions, I would just like to clarify on my co-counsel submissions under the last element of Article 3.2 second sentence, in stating that in observing the design and the architecture of the specific NZFA that has been imposed, we can observe that it is based on a variable here, the carbon emissions of countries. And with regards to these carbon emissions, the tax is levied based on the specific emissions. And the only contention that the complainant has raised is the fact that the respondent has already taken efforts with regards to cutting down on its GHG emissions, and that would be the only reason which the respondent will pay a lower charge.
Counsel, the complainant has also raised the point that you've introduced this measure at a very convenient time for yourself, after your producers have had a chance to decarbonize, after they have received subsidies to decarbonize, and that possibility simply does not exist for the complainant. Should we take that fact into account in examining the protectionist intent or any other element of the complainant's claim? And if you think that we should disregard it, why so?
Understandably, members of the panel, we can see the contention that the complainant has with imposing this measure. However, our own consumers, in accordance with that Truth Info poll, have considered the climate change an existential risk, members of the panel, and the government has taken this measure in response to the consumers' contention here. Indeed, while Madam Polovets has highlighted the fact that Ruthenian producers have begun their decarbonization efforts, we argue that this is solely Guta, and the fact that they have carried out decarbonization efforts should not factor in with regards to the fact that we have not imposed this measure with regards to protection, but as a response to our consumers' interests here. If there are no further questions under this point, members, I now seek to indulge you with regards to justifying any inconsistencies that you may find with our measure. We shall argue that the NZFA is indeed justified under the security exceptions, as well as the general exceptions of the GATT. We shall begin with the security exceptions in arguing that the NZFA is indeed a measure taken for the protection of Ruthenia's essential security interests in a time of a climate emergency, which is an emergency in international relations. As we lay out our assessment of this specific provision, I understand Madam Panelist has a question.
Excuse me, Councillor, just very quickly before you proceed with the specific details of your argument, can you please clarify to the panel why are you raising Article 21 first as a defense in this case? And is the fact that we have a specific environmental exception in Article 20, as you know, in some way prevents you, maybe not, but if not, then explain why, from raising Article 21.
Members of the panel, respondent is free to elect any claims under which it should seek to, free to elect any position under which it would seek to justify its measure. And as we recognize indeed that Article 20 does indeed contain subparagraphs specifically for environmental protection, we highlight that the environmental crisis and the climate change situation has security implications, an effect on the security interests of Ruthenia, and that is the hinge upon which we have laid our claim under the security exceptions. We begin with the security exceptions, given the existential crisis that our citizens are facing and the security implications that are an offshoot of the environmental situation. Excuse me, Council. You said that we have a specific provision to deal with environmental issues. In the presence of a lex specialis, shouldn't we actually look at that provision first? Or should we actually maybe not interpret Article 21 as not covering environmental measures, given that we have a specific provision on that issue? How do we deal with the relationship between the two provisions, beside the fact that you are raising that claim first?
Members of the panel, the respondent here has indeed leveled a claim under the general exceptions as well. But with regards to that specific question, we understand here that the respondent's contention is not solely with the climate change crisis. It doesn't stop at the rise of GHG emissions, but additionally to the rising sea level rates and the displacement of citizens that has security implications. As such, the security exceptions are proper ground upon which the respondent shall build its claim concerning the security implications of the environmental crisis. And in beginning here,
Are you, is your Article 20 argumentation or attempt to justify your measure, is that completely in the alternative to your defense under Article 21? Or is it something that comes together with? And if it is not completely in the alternative, can one and the same measure be justified both under Article 21 and under Article 20?
in answering
And if so, if you interpret Article 20 and 21 in that way, are you then interpreting it in a manner that is consistent with the effet utile principle of interpretation? Because why would you then still ever invoke Article 20? So start with the first, the alternative or arguing both at the same time?
certainly, with regards to that specific question, we indeed argue that Article 20, our claim under Article 20, is an alternative to the claim under the security exceptions. And concerning your second question, it indeed can be justified under both the security exceptions and the general exceptions. This is given the fact that the situation existing in Rutenia can be considered under two specific ambits, this being the climate change situation that exists due to rising emissions, that will indeed factor under the general exceptions of the GATT that tend to environmental protection, as well as the effects of those environmental situations that exist that will indeed factor under the security exceptions element of the GATT. And this will not affect how we interpret the specific exception.
So just one small clarification. I thought I heard you say in the beginning that you're raising Article 20B, not Article 20G defense. Is that correct?
Yes, members, we will raise a claim under Article 20B.
So could you explain perhaps to us, because we've been having this discussion about there being a more specific exception dealing with this situation, and you seem to agree with that, but at the same time, you raise what would seem to be, at first glance, a less specific exception that relates to public health. So could you explain the logic of your choice to us? Why did you decide not to go for that more specific exception?
Members of the panel, in elaborating the logical basis of our claims here, concerning specifically Article 20B, we recognize that it is put in place for the protection of human life and health. And while indeed there is Article 20G that exists for the conservation of exhaustible natural resources, we have presented our claim today based on the specific concerns that have been raised due to the climate emergency, and specifically the fact that there have been evidence of the rising morbidity and mortality rates of citizens due to the climate emergency, as evidenced by paragraph 12 of this record. We have based our claim under Article 20B to address these specific concerns, given the fact that our measure is tending to the causal origin of the factors that are indeed affecting human life and health. If there are no further questions, members, we shall now proceed to begin our security exceptions, members, specifically by arguing that the NZFA is a measure necessary that has been put into place for the protection of Rutenia's essential security interests in a time of a climate emergency, which is an emergency in international relations. Under this point, members of the panel, we understand that the adjectival clause in the specific provision extends solely to the essential security interests and the necessity of a measure to protect these interests. As such, the subparagraphs of this provision are amenable to a determination of the factual circumstances existent. We shall begin by claiming that the factual circumstances under which Ruritania and the international community in general exist, that is the climate emergency, constitute an emergency in international relations, and subsequently that our measure has been taken in a time of such an emergency. Under the chapeau of this provision, we recognize that it is still not entirely left to the invoking member, and that the panel may make a determination on whether our invocation has been made in respect of our obligation of good faith, and we shall attend to this as well. With regards to the subparagraphs, members of the panel, we recognize that the complainant has based their claims on Russia traffic in transit and has referenced multiple cases such as US origin marking. However, we seek to go straight to the text of this provision that states that the measure may be taken in a time of an emergency in international relations. And we seek to extrapolate the meaning of an emergency in international relations. An emergency, members of the panel, has been considered to be a situation of utmost gravity, a serious situation which requires immediate action. In the assessment of the specific provision by the panel in US origin.
Just doing what you're doing, which is looking at the wording on its own and the de novo interpretation, if I had to look at it, isn't the fact of the Paris Agreement, the fact of the UNFCCC, the fact that there's actually huge collaboration and cooperation among members, a suggestion that there is not an emergency in relations between states? There may be a climate emergency, but as to the actual wording of Article 21, it's not really captured by what we're seeing as really cooperation among countries.
Indeed, Doctor, we recognize the Paris Agreement and the UNFCCC are in place for the climate with regards to attending to the climate crisis problem. However, we construe that the reason our claim is based under the security exceptions is that we cannot consider the climate crisis problem externally or drawn out from the effects of the climate crisis problem, which do have security implications. Members of the panel, with regards to Madam Panelist's contention on the fact that this does not constitute an emergency in international relations, this goes straight to how we understand the meaning of the specific provision. Indeed, the panel in US origin marking determined that there should be a breakdown in international relations. We disagree with this point, considering that we do not need to see the existence of severance of relations between states in order to constitute the existence of an emergency. This is due to the fact that this is due to the fact that it would not be solely the severance of relations.
Council. Okay. You're trying to give meaning to the concept of emergency in international relations. And I think I heard you say the case law doesn't really help us, but we're going to have our own interpretation, which is a good thing. But in that effort to come up with a new interpretation of what an emergence of international relations is in the 21st century, how relevant is, and I'm building on a question that was already asked, how relevant is the Paris Agreement? And more specifically, is there anything in the Paris Agreement, in the obligations, or in the principles that are reflected in the Paris Agreement, that would amount to rules of customary international law? And how would that help or not help you in your interpretation? Now, I'm not asking you to say how it would not help you, but how would it help you?
Certainly, Professor. With regards to the Paris Agreement, and we recognize that our complainant applied it through Article 3.2, Article 31.3c of the VCLT. While it would be relevant, the Paris Agreement here in our interpretation, we would not use it or apply it with regards to a relevant rule in interpretation of the treaty here. However, we will introduce the Paris Agreement under our general exceptions claim under Article 11 of the DSU to highlight that it should be considered by this panel with regards to making an objective determination of the facts. Just to clarify, we would not urge an interpretation of the Paris Agreement, given the fact that it is not a covered agreement. However, with regards to the factual circumstances of this case, and the fact that the NZFA has been drafted in furtherance of the goals of the Paris Agreement, it is indeed relevant in understanding the intention of the respondent. An assessment such as this was conducted by the appellate body in EC Bananas 3, where they assessed the Loam Convention in determining the extent of the waiver granted to EC.
But do you see any relevance in your effort to interpret the concept of emergency in international relations?
With regards to interpreting the concept of an emergency in international relations, the Paris Agreement would be relevant here in bringing in the element of an environmental crisis and considering the fact that the WTO preamble has stated that in light of the environmental situation, the provisions of the GATT should not be considered as static but evolutionary in light of the emerging concerns of the community of nations. And as
Preamble of the GATT says that?
apologies of the WTO, the Marrakesh Agreement, members of the panel. It has been highlighted.
Says that explicitly, or that's an evolution of case law?
Apologies. The explicit phrase that is used is with regards to sustainable development and the evolution of case law, such as in US Shrimp has elaborated. I apologize for the misstatements. And with regard,
I think there's a question from our colleague.
Yes, thank you very much. Just to pick up on that point, I think the complainant submitted that we shouldn't follow the approach that you are suggesting of evolutionary interpretation as per US Shrimp in determining what an emergency in international relations is today, as opposed when what it was in 1947. When the GATT was drafted, we shouldn't follow that approach because it will open a Pandora box in the WTO, and that we need to be mindful of the systemic implications of our decision. Could you please respond to that argument?
we understand this, members of the panel, and in preferring our assessment here, we do not wish to claim that any singular crisis could factor in under Article 21. However, there is a requirement to identify an observable threat to the interests, the security interests of the country here. This is confirmed specifically by the negotiating history of the GATT, whereby the United States, in proposing the specific exception, did indeed highlight the fact that while it had not entered the Second World War, there was a threat to its interests that could be posed by the larger crisis that was ongoing, and that the security exceptions would be relevant in protecting those interests. While we do understand that there would be while we do understand the possibilities that would extend from opening up this exception, we argue that what should be provided before a panel in claiming or in justifying under Article 21 should be the existence of an observable threat capable of having an adverse impact on the security interests. In this specific situation, members of the panel, we argue that the climate crisis has been observed to have an adverse impact due to the rising sea level rates and the rising levels of displacement that has resulted in the migration of Athenian citizens into Ruritania, 300,000 Athenian citizens. And that as per clarification question 31, this has resulted in rising social tensions between the two parties. Members of the panel, the quintessential functions of the Ruritanian state here have been threatened, this being the protection, I understand.
Counsel, I think the complainant said that there is also this requirement, the temporal requirement, that the in time off should be satisfied. And I think the complainant's position is that it has not been satisfied because the effects perhaps are not as evident for Ruritania just yet. Could you please reply to that? Is this temporal requirement satisfied?
With regards to this temporal element, we consider the fact that the implications that have been placed on the first element of our test that the nuances that have been provided in the first element of our test would have implications in how we understand the temporal link. As such, the temporal link here that we seek to establish will be on the existence of the threats to the essential security interests of Ruritania and the imposition of the measure. To this effect, we argue that the existence of the facts that provide a threat to the essential security interests do indeed constitute a temporal element, here being first the migration of Athenian citizens into Ruritania and the resultant social tensions between these two parties. This was evidenced in 2021, and the NZFA was imposed in September 2022 as an offshoot of these specific events, and it has been placed
to
So if I understand you correctly, your argument is that a simple threat is sufficient to satisfy the requirements. You don't need to have the threat materialized.
not merely any threat, but threats to the essential security interests and the capacity for these threats to exacerbate as time goes on, specifically in this instance, due to the environmental situation that is currently ongoing. With
But-
regards,
Counsel, ultimately, this so-called threat to the essential security interests is a threat to the survival of the citizens of Rotania, right? So if you are looking at the threat to humans, we already have the provision under Article 20B explicitly for that purpose. So why would you ask us to radically expand the scope of Article 21 when you already have another provision which squarely address this issue?
members of the panel, the reason that we come before you under Article 21B3, members, is due to the fact that while indeed a central feature of the environmental crisis is the detriment to human life and health, it is also, the security implications of the loss of territories and the scarcity of resources that results from the climate emergency, and that this would have security implications necessary to be justified under Article 21B3. But we shall further address the Article 20B element, members of the panel, given the fact that it has been pointed to multiple times by the specific panel, if indeed Mr. Chair could grant me 2 minutes to dive into these.
That's fine.
Under Article 20B, members of the panel, we understand that it requires that the measure be necessary for the protection of human life and health, and that the assessment to be conducted here has 2 limbs, specifically a weighing and balancing assessment of the importance of the interests, the contribution of the measure to the interests, and the trade restrictiveness of the measure. Additionally, it requires establishment that reasonably available alternatives exist. We shall go directly to the
Counsel. Given that you have limited time, I'd like to jump directly to the alternative measures. In particular, I'd like you to tell me why, so for the default values of your measure, you bias them on the 5% of the least efficient installation. And then secondly, when it comes to verifying the emission, it is quite burdensome for foreign countries because they have to use your verifiers, entities established in your country. And these 2 elements, to me, are quite trade restrictive in how you design the measure. And wouldn't it be less restrictive to remove them, yet achieve the exact same goal of your measure? So how do we deal with these 2 particular elements, which seem to me quite problematic in your measure?
Certainly, members of the panel, with regards to the first contention that has been raised on the 5% worst performing installations, we understand here, members of the panel, that the default charge is necessary here due to the fact that there are countries, such as the complainant country, that lack in requisite reporting and recording mechanisms. And the default charge has been imposed to allow them to be charged based on a certain value. The provision of the 5% worst performing installations here has been imposed to provide a scope with which the emissions of those countries may be taken into consideration. This provides an incentivization effect for the reduction, members, of the for the reduction of the emissions, and thus would constitute an achievement of the overall goal of the NZFA.
Counsel, excuse me, but since the value are based on your worst installation, the only incentive for their country is to design a monitoring system, which for a developing country is potentially quite expensive and time consuming. So I don't really see how that relates to the aim of your measure.
Certainly, Mr. Panelist, we understand this contention that you have raised.
Thank you. Thank you to both parties for your pleadings. I would like now to invite the complainant to present the rebuttal. One thing that we may have not heard a lot about is engagement on the issues raised by the chapeau of Article 20, which could be interesting to hear a little about in your rebuttals and sub-rebuttals. So with that, I invite the complainant to present the rebuttal.
Thank you, members of the panel, Mr. Chair. And the complainant has 4 main points for rebuttal. The first one is likeness. The second one is other duties and charges. The third one is Article 21, and the fourth one is Article 20. And we would like to start with likeness. And respondent itself admitted that case provides no explicit evidence how industrial consumer may act on behalf of the final consumer. And that is literally the position of the European Union in its EU palm oil case. And in that case, the panel decided that it is most likely to be just a business decision dictated by a change in regulatory environment. And we see this change in the regulatory environment for DIM as well, because it is guided by profit. And DIM literally witnesses how much carbon charge he will pay for Burlandian, Persanian, flat glass, and nothing for Artanian. That's why we still believe that our products are alike. Now we are moving to other duties and charges. And here we still believe that carbon charge is a separate measure, because any differences in administration does not lead us to the conclusion that there are two separate measures. And such decisions were reached by the panel in Argentina Hyzon leather case, where importers were also subject for prepayment and certain other peculiarities. And for these reasons, we believe that carbon charge is still internal tax. And we, of course, want to comment on the argumentation as to different application of the carbon charge with respect to default values. And it isn't in itself a separate application because, for example, we may witness such situation in the Dominican Republic cigarettes case. And in that case, the measure was pretty similar to ours. And the tax basis, the tax payable from imported cigarettes was to be calculated based on the information from the Dominican domestic republics. That's what we had in our case when we're with Burlandian and Ruthenian flat glass. And in that case, the measure was internal tax and wasn't divided between border and internal one. Moreover, we would like to state that the argument as to the prevention of importation cannot work in our case because even some internal taxes are prepaid at the border, for example, value-added tax, and the products which are subject to value-added tax may also be prevented from entering the country if no tax is paid. So this factor isn't testified that the measure is border. And with respect to Article 21, and precisely as to the requirement of in time of, respondent referred a lot to Artanian crisis, but to show us the emergency and the consequences of this emergency. But however, we point out the panel's attention to rather strong statement that is dated 2022 and is provided in Article 11 of our case. And back in 2020, Ruthenia warned the whole region that carbon charge will be introduced not to disadvantage its domestic producers vis-à-vis importers. And back in 2020, no Artanian crisis took place, but the evidence of it was provided only in 2021. For these reasons, we believe that the requirement of taking in time off isn't satisfied, and Net Zero Future Act itself doesn't contain any reference to Ruthenian essential security interest, that is climate and safety in the region. And with respect to our last point of rebuttal, that is Article 20 and Chapeau, and here we would like to talk about the exemption measure. And we believe that exemption measure leads to arbitrary and justifiable discrimination between the countries where the same conditions prevail. And here we refer to UNFCCC Convention, and this UNFCCC Convention equals LDCs and seeds to countries with forested areas, that is Burlandia in our case. And both LDCs and seeds and countries with forested areas shall be duly taken into account on equal terms. And for these reasons, we believe that exemption measure leads to discrimination between countries where the same conditions prevail. And we would like to finish our rebuttal by citing Dr. Ngozi and its statement, namely that often climate measures used by developed countries as a pretext for protecting their domestic producers. And the most valuable approach here is a carbon pricing that will be discussed and enforced at the regional dialogue. And that's what Burlandia proposes us to do. Thank you.
Thanks to the complainants for their rebuttals. May I now invite the respondents to present their sole rebuttal.
Members of the panel, with regards to the first contention on likeness, that there was no explicit evidence, we agreed on this a while ago, that we consider there's no explicit evidence that the industrial consumer is acting on behalf of the ultimate consumer. And our point was that previous appellate body decisions have recognized this when they cannot determine evidence of consumer purchasing behavior regarding the ultimate consumer. And we have stated that these have been taken into consideration when there are sufficient risks to infer this consumer purchasing behavior in ideal markets rather than the real and current market. And this is why we submit that the panel can still take into account the preferences of the ultimate consumers in an ideal market, and that the presumption that the industrial consumer or the immediate consumer is acting on behalf of the ultimate consumer can still be made. The complainant also stated that the immediate consumer is guided by profit. We wish to note on a brief note that that is also an assumption and not stated in the record. On the second point, that the measure wasn't divided into internal taxes and the ODC, certainly we agree that there are no specific categorizations in the measure. However, as was stated by my co-counsel, with regards to article, the entire NZFA is a regime, as was stated by the appellate body in ECCL products. And in a regime of trading measures, there are certain measures which have differing obligations. Article 3.1 is a measure, and Article 3.2 is a measure. And if you look at the terms of reference of this panel, the complainant is challenging the imposition of the charge on them, and imposition occurs by Article 3.2 and not by Article 3.1 of the NZFA, which we have demonstrated is triggered by the importation of the products, and thus is an other duty or charge. With regards to their opposition to our taken in a time of submission under Article 21, it is our submission that Ms. Reda Strong's statement is provided only with regard to the rise in emissions. And the sole reason that Ruthenian producers produce lower is because of decarbonization. And if you look at the record, specifically at paragraph 4, you will see that decarbonization efforts began in the year 2016, shortly after Ruthenia joined the Paris Agreement. And finally, with regards to Article 20 on the chapeau, Council has raised the UNFCCC. It is our submission that the exemption measure is done in light of the respective capabilities of LDCs, which cannot take into account the costs of the climate crisis, given the fact that they are, first of all, least responsible for this devastating impact in the environment, and second of all, they are incapable of taking more expensive measures compared to developing countries. And in any case, members of the panel, let us not forget that the Paris Agreement was enforced as a subsequent agreement to the UNFCCC. And if we are to side with one of the other agreements, let us side with the Paris Agreement, which Article 4.6 provides that LDCs and seeds may take into account NDCs, and the same exception is not provided for developing countries. So there's really a misstatement there, or the complainant might mislead the panel in seeking to show that developing countries and LDCs are at the same level, which we submit that they are not. That would overlook the entire framework of Paris. And in also concluding our submissions, we briefly state that the urgency of our environmental crisis demands innovative solutions that align with multilateral trade obligations, and the NZFA is Ruthenia's bold contribution to this global endeavor. And we have demonstrated through our submissions that GATT obligations can coexist with ambitious ecological goals. Thank you for your time.
So since we have a few seconds left, I'm tempted to ask a question. Is it your contention that the Paris Agreement does not recognize that developing countries may also need special assistance in implementing their nationally determined contributions?
No, Madam Panelist, that is specifically recognized in Article 4.5 of the Paris Agreement. However, Article 4.6 provides further exceptions or special circumstances for LDCs and seeds. So this is demonstrating that although developing countries also have needs, LDCs are in a specific dire situation in comparison to developing countries. Thank you, members of the panel.
Thank you to both parties for your rebuttals and rebuttals. Ladies and gentlemen, the panel will now retire to complete their marking sheets and prepare comments for the parties involved. The panel will rejoin for an informal feedback session whereby we will provide comments to the competitors on style and structure only. Thank you, everybody, for your cooperation. Thanks to the parties for your participation.